Good, good morning, everyone. Thank you for joining this very interesting discussion. I promise it would be very interesting. So we're very glad that you came to listen to these two distinguished speakers that are here with me. Let me first introduce myself. I'm Claudia Martinez. I'm working in the European Commission in the department that is called DG Grow, which stands for Internal Market, Entrepreneur, SMEs, and Industry. And I'm the Deputy Head of Unit dealing with intellectual property rights, which is obviously a very vibrant part of the areas that make industry more competent, and that for us, it's today the good opportunity to bring to you the venues, the latest developments, and the opportunities that IP can actually offer to industries, but also particularly to SMEs. And I'm here with, as I was saying, two distinguished speakers. I hope you can hear me despite all the noise around. I will start with Caterina Campari. Caterina is the team leader of the department of EU IPO responsible for the implementation and the revision of the Agri-GIs scheme, but also looking at geographical indications more broadly in the EU IPO. She has had previous experience as well in the European Commission in the and she was also member of the board of the Croatian office, the Board of Appeals. She also has long experience in the private sector. We also have Robert Buck-Clinton, pronounce it correctly. Robert is also a consultant and advisor on IP matters. He is actually working in the IP help desk Latin American. He is giving trainings and matching events and basically promoting IP across the world. He has worked previously in the EPO and also in EPI in Munich. And today, the discussion that we want to bring to you really focuses, I would say, in three main developments in the landscape of IP. We want to focus first on the new scheme to protect craft and industry products on geographical indications. We also want to bring to you the latest developments on the policies we are taking to support SMEs throughout the SME fund, but also the help desk. We will hear as well from Robert. And we also want to, as is unavoidable, refer to patent, because that has been also a milestone in this year, 2023, very important for the IP developments. And with that, maybe just to also give some context, because we are in the EU Industry Days, we're focusing on industry, and why IP is then, brought into this broader discussion, again, because it's not only super important for industry to protect their inventions, to protect their designs, to protect their products, their brands, their reputation, but it's actually producing a high impact on our economy. I mean, we're talking about IPR intensive industries that are accounting for 30% of our jobs, 47% of EU GDP, and also they are promoting this surplus trade that we have in terms of exports and imports. We were talking about, I think it's 224 billion that we have accounted that comes from IP-intensive industries in all different sectors. So again, IP really matters. But now going to zooming in, first item that we wanted to bring to your attention, this is the geographical indications for craft and industrial products. This is very close to my heart because from my department in the Commission, we've proposed that new system last year. Now co-legislators are about to finalize, and we will have the new regulation setting up this new geographical indication for craft and industrial products very soon. I mean, we're talking about a month time where finally this type of products will enjoy of an union protection that will also be able to be replicated at international level, so we're having this double protection. And that's, of course, a premiere. And this will benefit not only producers of those products, but also, of course, consumers that will have finally more transparency about the quality of such products. And, of course, regions. That's also extremely important for regions that are producing those products, that are linked, connected to that geographical indication by, for example, promoting further tourism, but also promoting the retention of jobs, skills, and traditional know-how. And with that, this is a system that it has been established for the agency in Alicante, the so-called EU IPO, to run it, to implement it. So it will be the EU IPO, obviously together with member states that will play an important role. And having here Caterina, I want to take the opportunity to ask her to enlighten us about what has the EU IPO done so far in the area of CIGIs, in the area of GIs more broadly. What's the expertise they bring in? What is actually the scheme that we are now going to be rolling out? So what are the main features that this scheme is actually having? And what type of products will be covered? What type of protection we will be giving? Caterina, over to you.
Thank you. Thank you, Claudia. Thank you, everyone, for joining this session. Obviously, it's a pleasure, a distinct pleasure to be here today with you on the behalf of EU Intellectual Property Office. And as we have heard from Claudia, this might be a new competence coming to the office very, very soon, but it doesn't mean that GIs as intellectual property rights have not been already part of our daily activities. I hope you can all hear me well, but if not, just a raise of hand and we'll fix it. So what have we been doing as the office in preparing ourselves to receive this new competence? We have been working already for the past 5 years within different arenas that involve GI knowledge. So one of those is GI examination. We have been helping DG Agri, so the DG for Agriculture and Rural Development of the Commission, that you all well know is in charge of examining and registering agricultural wine and spirit drinks GIs. We've been helping them in the pre-assessment of those applications coming in. We have been providing GI training. If you go at any moment to the EU IPO's website, even today, you will be able to look for webinars, conference materials, learning materials on GIs. More than that, so more than and beyond the borders of the EU, we have been involved for many, many years now in different cooperation programs that stem globally, where we are helping countries outside of the EU to understand what GIs are, how they can be protected, and how to set up their own rules. We have been involved in over 100 GI-related projects in terms of cooperation. And then we have been developing some tools. You will be hearing later on something about the GI view. So this is more or less what has been happening over past 5 years. In the meantime, and as the revision and the review of Agri-GIs and then a setup of the new craft GIs regulation has been coming up, we've been there to support the Commission, but also to technically prepare ourselves. I will be going in those details a little bit later on. So what is to come? Many things, as you can see. For the first time ever, there will be a unitary title for craft and industrial GIs. What does that mean? It means that a well-established policy for agricultural products, wines and spirit drinks, to have them protected as a GIs. It's been over 30 years at EU level. For the first time, other sectors will get exactly the same opportunity to have a geographical indication protection recognition for their products. So what are the products that can come under this new scheme? Jewelry, textile, stones, cutlery, ceramics, glassware. I'm pretty sure if you all reflect on your own countries of origin, where you come from, I'm pretty sure you will be able to pinpoint at least several products of craft and industrial nature that you might think, well, these are the products actually that sort of connect me to that particular area within my own country. So we will have to establish, as the office, we will have to establish different procedures, and you will see maybe a better timeline for it later on. So we will be drafting guidelines, we will be bringing in decisions in the first instance, but also the boards of appeal, the current boards of appeal within the office will be the second instance for those decisions. We will not be doing this on our own, and you will see how member states will have a very important role in this process. IT tools. We will have to look into developing several tools because there is nothing so far. So what are we already doing? We're already analyzing the new application system that we call GI Portal for all the producer groups and member states to adhere to. We will have to set up a union register, a single point of entry, and then we will speak about GI View. Some of you might have heard of it already. Cooperation and costs, I will not go into details now because I think I've covered quite a lot of what's coming up. Claudia.
Can you tell us a bit more in detail what are the role that we foresee for the producers and also for the member states? Because certainly that is a system that will require a lot of coordination. So,
thank you, Claudia. Before I go to that, maybe just to stop here for a second to explain what will be set up with the new system. I said a unitary title, but unlike in AgriGIs, here we'll be looking at protected geographical indications only. So this will be this blue logo that hopefully you will be able to see on many new craft and industrial products. This is a logo that actually certifies, verifies to you that something has been produced according to certain rules. But who will be the main players? Without any doubt, it will be the producer groups. They will have the most important role, I have to say, as they will be the ones initiating the whole process. So the EU IPO kind of comes at the final stage of this work that needs to be done before we can speak about GI application even. So the producer groups will be there to set up, first of all, a group of producers, to set up internal rules, and to draft product specifications. Then they will have to draft the full GI application file. So this GI application file will consist of the product specification, what we call a single document. You will be hearing a lot about single documents in the future. They exist today already in AgriScheme. And I would dare to say that the new craft scheme has actually built on the best practices from AgriScheme to bring a more agile, a more simplified procedure with equal level of protection. So the producer groups will have this role to provide the competent authorities and then the EU IPO with all the important aspects of a product to be protected under GI.
yes. Go ahead, Katerina, go ahead.
So member states, maybe the role of the member states. As we already mentioned, member states will have the most significant role. The system still envisages a two-phase role. So once initiated by producer groups, the file will be looked at the national level by competent authorities assigned to be in charge of these files. They will have to assess that all the details in the product specification and in the single document actually are correct and verifiable in the region and on the market. But this system, as I said, worked on the way to think of what would be the best practices and how do we achieve something more than in agri-process. And therefore, there is also a possibility of direct registration. This is a complete novelty. This does not exist in AgriScheme. What does it mean? The Commission has realized that there might be member states who do require a different approach to GIs. Different why? Because they might not have currently a GI system in place, and then we know setting up a new system always takes time and it might have some administrative burden. And then second of all, maybe there are not that many producer groups willing to, and there is no interest to file for this type of protection. Those member states will have a choice to opt out from the system, but they are not completely out of the system. Even under the direct registration, they will still have to appoint a single point of contact. That would be important for the office, because the office, the EU IPO, will then take over, so to speak, the national phase of the process. So the producer groups will file directly with the office those applications.
Yes, and can you also tell us what are EU IPO's future services in the light of this new scheme that you are actually already putting together to implement it?
Thank you, Claudia. So this is the slide that I wanted to show you in particular, because I think in linear way it shows you what is coming to the office. The application, the examination stage, the publication for opposition itself, and then the first instance decision. This can all be appealed to the boards of appeal, and then later on to the General Court if there is such need. There is also an interesting point where the Commission itself, in exceptional circumstances, might decide to get involved in a particular file for various reasons. What the office is preparing at the moment to do, because we are in the implementation phase, we are looking at development of IT tools. We are looking at how to provide the best customer service to these new users, because up to now we have been dealing with trademarks and designs only. So getting charge of public collective right, of course, needs to be affected through our procedures as well, or addressed in a different way. Also, it's very important to know that the EU IPO will be named, or is named, as a competent authority under the Geneva Act. Geneva Act is the act that is administered by the World Intellectual Property Organization, meaning all the countries signatories that do have craft and industrial GIs, if they decide so to have extended protection on the EU territory, it would be the IPO, EU IPO, who looks at those applications as well. Finally, we will be providing technical support when the Commission negotiates international agreements.
Thank you. And can you tell us as well about the technical means you're putting forward to support transparency also vis-à-vis the products that can be protected? Because obviously, Katarina has made the point, it's not every type of craft and industrial product that can be eligible and protectable under this new GI scheme. It has to have this special link, characteristic, reputation that is substantive, and it's linking it to the geographical indication. So maybe you want to tell us about that as well.
Yes, thank you, Claudia. So I have to draw your attention here to a tool that Office already has. It's a GI view. Currently, it only shows the existing unitary titles for agri products, but in the future, it will surely show all the products that are protected in the EU, including those craft and industrial products. It's a free tool for the users, for the competent authorities, to basically promote further beyond the EU the products themselves. So I would really call you to see how it can help you find the information you need. If you work for control authorities, how to control a certain product. If you're a user who's just going to a supermarket next day, you might find some information there for yourself as well. And now on the future outlook. So what are the important milestones for the office? We are really looking forward. As Claudia mentioned, there is already a review ongoing of agriculture scheme as well, that we do finally end up with the alignment of GI concepts. As I've shown you at the beginning, there is a blue logo. The blue logo is used already in agri scheme, so there is this connection. And the definition of this PGI product for craft and industrial products is exactly the same as in agri scheme, meaning it's a product coming from a particular region whose reputation, quality, or any other characteristics are essentially, and this is very important, essentially attributable to this particular origin. We are really still hoping that we might in the future, if not now, see a single union GI register, so the register for both agri and craft GIs. We are currently in a process of setting up advisory board. Advisory board is also a novelty under this scheme. It will consist of the representatives of Commission and all of member states, and will help the office in establishing guidelines and providing opinions on different horizontal matters. As you can see, the entry into force of the main regulation is foreseen for next month, and it's really a question of time when it comes into play. And then we're going to be waiting to see what the secondary legislation, which is also important, will provide as further details. And this is my final slide. Advisory board will have a very particular role in the future. It does not exist today, so the office will set up a network of connecting member states and the Commission to be able to sit in plenary and speak about horizontal issues that are important for the application of the regulation. How do you assess the generic term within a name, for example? But then also they will have a further role in case there is any dispute and the office or the boards of appeal or Commission itself feels that there should be an expert opinion. They will be sitting in panels of 3 and provide answers to concrete questions. And I will stop here. Thank you all so much.
Thank you, Katarina. Indeed, this is a lot of work to ensure that we have it all up and running by, we expect this November 2025. This is when the new system will be fully applicable. And that means as well from the Commission side, working hard to ensure that all the implementing and delegated acts are adopted by then, and obviously working hand in hand with EU IPO in ensuring the rules of procedures for the advisory board and all the different technical sides are well developed, not only in the EU IPO, but also from the member states side, where they will also need to have efforts to undertake to ensure that producers at their side can already protect, for example, at union level, what they have protected at national level, so that they actually inform us of that titles. And this is part of the work that now in these next 2 years we will be developing. I stop here, and I don't know if there is any question for Katarina on this interesting topic. Otherwise, if we go and continue with the topics we wanted to bring today to the table, I'm gonna give you a bit of a, maybe next slide. I don't see any questions here in the audience. Maybe you can check if we get the questions from the online audience, because there is also a participation online following this debate. So now looking at the SMEs' role and intellectual property, what we have identified, and that was already flagged in the action plan 2020, is that despite the value that IP can actually bring to companies, and it's been proven that SMEs and companies in general that have intangibles protected, registered with IP rights, are actually generating a much growth income per employee. But despite these facts, we still see that SMEs, particularly SMEs, do not actually register IP rights. It's a multi-factor aspects that make SMEs less prompt to register the IP rights. We're talking about often being a very complex field, being as well perceived as very expensive. We also have done our own assessment that the current legal framework is not necessarily fit for purpose for SMEs. And also sometimes if we looked at, for example, the access to specific patents, and in the context of essentially standard patents, there is often barriers to access them for SMEs. Also, for example, when looking at fighting counterfeiting or, for example, making their value, their IP being enforced, it's also something where SMEs may actually not have the resources, don't have the knowledge, and hence with all these identified shortcomings, what we have done so far is to try to sort of act at different layers. The first layer has been when reforming the legislative framework, taking the SMEs angle into account in each and every step that we take in terms of adapting the legal framework. And I'm talking here, for example, we've just discussed the geographical indications regime, certainly extremely important for SMEs because craft and industrial products are often made by micro enterprises, even single producers. But also if we looked at, for example, the reform on Design's EU legislation package, where we have proposed as Commission to reduce the fees, that is also having in mind, for example, the access for SMEs. If we looked at, for example, the patent package legislation that you may be aware that the Commission proposed this April 2023, where we have a number of legislative initiatives, for example, in the context of the standard essential patents proposal, where we have a chapter dedicated for SMEs, where we are actually promoting a special support services of the Competence Center for the SMEs, also reduced fees for SMEs. But it's not only on that front of legislative reforms where we are actually focusing on supporting SMEs, we're also doing it in the context of the policies we're bringing forward to support the fight against counterfeiting. In this context as well, we're working on recommendations that will address SMEs, notably also with cyber theft toolkit that will be bringing attention of, for SMEs to how best repeal cyber theft attacks, so that trade secrets, which are very important, non-registered, obviously, right, can be protected. We are also, in this context, offering specific support services for SMEs, and here I would want to basically go deeper in these two specific services, support services. One is the SME fund, and the other one are the help desks that we will hear now in a minute. And on the SME fund, just to give you an idea, I don't know to what extent those of you know about that SME fund. This is actually an initiative that was promoted by the European Commission in close cooperation with the EU IPO back in 2021 after the COVID crisis, where we sensed that there was a need to further support SMEs on the IP side. And this has been ongoing, this initiative has been ongoing and has been implemented with funds from the EU IPO and also from the European Commission, as I said, since 2021, with the idea to support SMEs not only in helping them finance the registration fees for trademarks, for designs, for more recently patents, European patents, patents with unitary effect, but also plant varieties. But not only this, we're also supporting them with this, what we call the IP scans. IP scans is basically this service where you can actually get consultancy advice to know, okay, out of your business model, what is an intangible that is worth protecting under which IP right? So that is concrete vouchers with money that has been granted to the SMEs. And just to give you a figure, for the budget 22 to 24, we have allocated 60 million. And if we look at how it's been used, well, here you see the different vouchers that I have just mentioned. But so far, in 2023, we already received 30,000 applications. This is quite huge. The beneficiaries are from the European Union established SMEs, but since June it has also been opened to Ukrainian SMEs. So already now there is at least 60 or 65 Ukrainian SMEs that have benefited from that SME fund. And you can see as well which IP right is being most used by the SMEs. Trademarks and designs certainly leading. Patents slowly getting up. This, again, just to give you a bit, the perception is mostly used, as you can see, from Spanish SMEs. Possibly there is a connection because the EU IPO is offering and implementing those vouchers, so connection helps in terms of geographical closing. But certainly this EU SME fund is being coordinated with all the national IP offices in all member states to ensure that there is raising awareness among SMEs from other countries. We see Italy and Poland ranking number 2 and 3, also Germany having lots of SMEs using these vouchers. And how it works, I will not go into detail, but just so that if you or in your networks you can replicate, you should, to get such SME fund, you should get first an application for the voucher before you actually register the trademark or the patent. So you first apply for the voucher, and then in 1 week you will get the award decision. Only after once you've got the award decision, then you go and you apply for the trademark, the design, or the IP scan. Then there is this 2 months activation period under which you should bring the invoice to the EU IPO to get yourself reimbursed. And then you have a time span of 6 months or 12 months in the case of patents to actually cover all the different invoices for which you would be able to be reimbursed. And we're talking about reimbursing. Have a look. IP scans is €1,350. For patents is 1,500. For trademarks and designs, we're talking about €1,000. So these are significant amounts for notably small and medium enterprises. I've also mentioned the cybersecurity toolkit. I will not go into detail. This is in preparation and it will be ready next May 2024. I've also mentioned other type of support services that we're giving beyond the SME fund, and this is the IP help desk. And here I want to turn to Robert to tell us a bit about what do the IP help desk actually offer, what type of philosophy does the IP services have, who are the beneficiaries of the IP help desk, and give us a bit of an overview of what is the journey that SMEs actually do when reaching out to the help desk. And I'll give you the slides.
Thank you, Claudia. It is such a great pleasure to be here, invited today to share the floor with Claudia and Katarina. I mean, great figures in the IP world, especially in Europe. And actually, people don't know, but when talking about the SME fund, what they're doing at the EU IPO, the great work they're doing is helping EU SMEs. And whenever at the IP help desk we're discussing this with EU SMEs, this is essential for them because they don't have funds. They're looking for partners and they need protection. So with 2 of them, actually we can see today that we can give some help, a helping hand here. So SME Fund, as Claudia mentioned before, it's helping them with the protection of intellectual property with great vouchers, I have to say. Today I'm going to talk about the IP help desks. The coverage of the IP help desks, it's, as you can see in this slide, is nearly worldwide. We have covered practically every continent. We have China, Southeast Asia, we have Latin America, we have India, Africa, and of course we have the European IP help desk, which has some extra because it's also focused for Horizon Europe projects, Marie Curie projects. As you can see, my branch is Latin America one, which covers 18, 19 countries. Southeast Asia covers 10 countries, China also has Macau, Hong Kong, Taiwan, and Africa has recently been provided by the EU IPO actually. They're starting and I think they're doing a great job. But what is it that we do? As I mentioned before, when I discuss with EU SMEs at matchmaking events, at trainings, they usually always say 3 things. The first thing is, do you provide funds? Can you help me with partners in Brazil or in China? Because they don't know anything. They're just starting. They would like to move around. But what we do is we try to help them with the third question. How can we protect this idea in Brazil? Or how can we protect this painting in India that we want to sell there? So these kind of questions, usually they are very general in the beginning, but eventually we try to put them in the right way before going to a IP law firm, allowing them to ask us any questions they may have related to intellectual property matters and its enforcement. And of course, everything's for free. That's the point where they always come back to us very happy. But the first thing is why intellectual property matters. It's funny because this question actually not in every event, but there's always a certain distributor or some kind of philosophy person who thinks that the intellectual property is not for us. As a company, we don't need it. But actually, they need it in most of the cases that they explain to me what they are doing. They have a process that they have not protected as a patent. They have not thought about the trade secrets that they may be involved in what they're doing. And of course, they may be infringing the trademark of another company when they distribute their product in other countries. And that's something they don't think about, and they need to do a pre-search for that and try to protect it before going to these countries. This is something that avoids them to have legal disputes. Of course, what we talk about afterwards is about the importance of a very good portfolio. It's different from a company that has no trademark protected, no patent, no industrial design, from another one who has a very nice portfolio to talk with another partner who might be interested in joining efforts and put them together in order to probably enter a new market, or to work between European countries, which is usually the first point that they raise, and that's when I talk with them and I put them in the right direction with the European IP Help Desk. Of course, they also have to know about the freedom to operate in the new countries. Thanks to the protection of intellectual property, they are able to travel to other regions of the countries, being sure that they are not infringing other third parties' intellectual property rights. And or maybe they don't need protection, they just have to think about trade secret and how to protect it with technological protection measures. And the whole orientation that we have to do this is because we are thinking about the EU competitiveness as such. We are thinking about changing the innovation ecosystem in Europe, so all the EU SMEs think about the protection of the intellectual property, in order for them to to enhance their company, to have better relations with other companies, to develop themselves internationally, and that's where we fall there.
Yes. Tell us, you've mentioned the beneficiaries already,
Yes.
and I wanted to understand when you receive the SMEs request, because they have to internationalize their business and they face barriers, obstacles. I can imagine different countries. It can be languages. It can be different, legislation affecting their rights, languages issues. I mean, can you explain us how, also from your experience, you are supporting those SMEs?
It's actually a very good question. Usually, per event, we try to meet as much as SMEs as possible, because that's what our international help desks are focusing, like helping the SMEs. What they usually come to us is, of course, they want to go to a certain country, but they are not aware about the barriers that may arise. Like a certain country, for instance, they may keep the innovation within the country. So even though they have a private contract, they would try to sign this type of contract, and then by the time they want the innovation for themselves as a propriety, it happens that they may have to release the innovative idea for the company in, let's say, I don't know, Brazil. I know in Sweden for European projects, it's something that you also have to bear into account. The language issues, I think that you mentioned, also is key, because Spaniards have it easy in Latin America. But of course, when I talk with Germans and Belgium, they think differently. They also see these issues, and this is extra fees that they have to think about. So whenever we talk with them, we can discuss about the fees that may be in between the Madrid system for trademarks or for the PCT. but they have to also think about the language fees, about the fees coming from lawyers that maybe have to represent themselves locally, and so on. But yeah, it's a very, very important issue. And as I was mentioned before, the Africa Help Desk, the Latin America Help Desk, China, Southeast Asia, and Latin America, they have a single focus, which are the SMEs that are from the European countries, and of course the single market program associated countries, which is now growing. I think now we included Ukraine and Montenegro and Turkey, etc. And they, of course, the important thing here is that they need to be either established in Latin America, in my case, our branch. They have potential interest in going internationally to Brazil, to Mexico, to Chile, or they are working with entities in the regions to distribute the products. And as I mentioned before, the European IP Help Desk, they also have a certain focus on the European Horizon projects. And they try to explain to all the beneficiaries of these funding, EU funding projects, what they have to bring into account with the grant agreement, with partnership agreement, and etc. So whenever, I mean, if anyone is watching online, just for you to know, check the European IP Help Desk in this case, if you are such a beneficiary. About the philosophy that Claudia mentioned before, just to briefly mention that we are preparing EU SMEs for the capacity building in intellectual property rights and their management. It's a solution-oriented and hands-on. We try to keep it very easy for them. We do not put into the game jargon, legal jargon that may be a bit complex for them to understand, but we try to keep it easy. Also, we understand their sector, so we try to put them examples from the field they're working in. We have a large pool of IP experts in all the regions and countries, and we also try to focus on thematic fields. If you go to our website, you will see that we have also different sectors and content on the different sectors that are the main ones in the different regions. And of course, yeah, specific services are targeted in the sense, for instance, in training. So I was meeting now, for instance, with one ministry, and they were, of course, focused about the agri-food business of Italy. Maybe there might be something that we can build up in a training session, online or on-site. And we try to adjust our content that we have to the sector they would like their companies to be prepared for. I will try to be very brief with all our services, but essentially the main service that we offer is the helpline, which is it's free. It's in 5 languages: in German, French, in English, Portuguese, Italian, and Spanish. And of course, we provide this in 3 working days. So by the moment we receive the questions from EU SMEs, we give a notice of reception, and in 3 working days, we work very, very briefly. We send it to the IP expert in the country, and we try to send it in the same language as we received it. It's German, then we translate it to German, and in 3 working days, they will have all the answers to these questions. But we also try to answer them in matchmaking events, in training events. And that's the second service. We provide on-site and online training events that we agree before with a collaborator or a partner, depending on how it's called in the IP Help Desk. We also provide with publications, as the EU IP also has their own. We develop our focus in the different countries and main sectors in my case, in Latin America, for instance. So we have a country fact sheet just for Brazil or Chile or Bolivia, and it would deliver all the IP rights and the certain particularities that you may find in different countries, as you mentioned, barriers. That's also we bring into account. In the website, you can see all these services. We also have a calculator, which is very easily workable, and we have an ambassador scheme, which is just for the European IP Help Desk, and it's in the case someone from Lithuania or Spain, and they would like to speak in their own language, they can ask directly to the ambassador scheme to access to the IP questions that they can address to our IP Help Desks. Very fast, as I said, it's free of charge. It's confidential. It's to the point. We don't like to send like long messages. We try to answer exactly what's been asked. We don't like to go like a snake. We just go directly to what they said, and we answer in 3 working days per email, phone, web, video conference. Actually, we try to adjust to any kind of any platform they would like to use, and as I mentioned, in 5 languages. The helpline, I would just like to mention that it's not a legal services. We are not competing with IP law firms, of course. We cannot give advice on patentability. You should go to a European patent attorney or a national patent attorney for this. These are complex issues, and of course you need someone that know the field, that know how to draft, and the language that the patent examiner will need. The representation services, of course, in case of infringement or enforcement, are of course out of our scope, obviously, that you should go to a lawyer, and for legal consultations about the best strategy to go to a certain route, whether one is cheaper or the other. Of course, at a certain point, we go by the hand. We give them all the information that they might need about the process, about the fees, about certain particularities. But if you want to think about the way of protection, the best way is best to go to a law firm and be well prepared for that. The trainings, as I mentioned, are online and on site. We try to prepare our audiences to know everything about intellectual property, to be ready in case they want to go on a mission to Brazil or on a mission to India. And we try to involve as many stakeholders and experts in the process. So we try to also work with chambers of commerce, technology centers as collaborators. Let me know if I need to be faster.
No,
It's okay?
it's fine.
Okay. As I mentioned, we have online resources. You will see in our website in different help desk, we have e-learning modules, videos on the trainings that we deliver online. We have guides, as I said, country-specific, like fact sheets. We have infographics. Now, each help desk is, of course, trying to target different audiences, not the same one going to Latin America than one to India or Vietnam or China. In our case, we are now creating something new, factographs, which are kind of infographics delivering all the particularities in a certain country. And I found that very interesting for our experts. We've also, we are now delivering also in Southeast Asia podcasts, for instance. So we are trying to create different things. And the case studies. Hereby, if any USME have questions about how our help desk is working, on if they need examples on how we help them, in the case studies of the different help desks, you will see how it works and how we have already solved some of the questions and maybe issues that have arisen to companies when they internationalize. The stakeholders, as I said before, we try to create synergies with them. We try to put support organizations together as stakeholders within the trainings and the actions that we try to carry out, obviously. And if any of you is interested in what any of the help desks is being carrying out, you have us in LinkedIn and in now X Twitter. And there you have in the website all the help desks that are available. And hereby you can find our email accounts. And of course, if you are physically at this event, please meet us at the Meet the Expert area.
Many thanks, Robert, for this extensive explanation of what the help desk are and what do they offer. Just an invitation, of course, to make sure you use the help desk if your companies are considering internationalizing, if I may say, not internalizing into single market, which is well with the EU help desk, but also going abroad to third countries, notably in the areas where we have them physically there in those different continents, because again IP matters, and IP can be certainly a push for your valorization as a company, but you can also face it as a big obstacle when entering a specific market. So thanks for these explanations, and I will just now move to the last part of the discussion that we wanted to bring to your attention, because we're talking about opportunities, we're talking about the value that IP can bring to your companies, and we are very excited that this year, finally, after more than 40 years, there's been the unitary patent seeing the light, and that is, I believe, a novelty, an opportunity that we cannot get tired from promoting it, because again, it is a novelty that will, in principle, facilitate the life of companies that want to protect their innovations in the European Union. So the unitary patent, and we will briefly go through the main aspects of the unitary patent scheme, is, as you can see in this slide, operational since 1st of June 2023. We from the European Commission, we've been supporting the launch of the unitary patent since years. And also to complement the entrance of the unitary patent, the Commission has also adopted the patent package that I was mentioning earlier in my intervention, which very briefly I will introduce, because it's actually complementing this new reality that we have in the patent arena. And in particular, I think it's important to frame the unitary patent together with the proposals that the Commission has done in the context of patents, as an attempt to harmonize particularly certain aspects of post-granting patents to leverage EU's competitiveness. And what we have introduced in the patent package, I will just briefly mention the three pillars that are part of that package, and also the cost savings that this represent for industries. We have on the first side introduced four regulations, proposed four regulations, of course, for the co-legislators to now take it forward, to actually adapt, centralize, and modernize what we call the supplementary protection certificates for what it is plant protection, so pesticides, and what it is pharma products, which is this top up of 5 years additional protection that is granted once the patent has expired. So it's this 5 additional years of monopoly, if I may call it that way, that the industry will be able to get. And what we have done with this new 4 regulation that you have proposed, and I know it sounds complicated, 4, but the logic is because we are creating a unitary SPC that will complement the unitary patent. So that's why this is actually if I can call it, the cherry of the cake, to ensure that the unitary patent can have its follow-up in the context of the supplementary protection certificates, which again, we have reformed also the national existing schemes to modernize it and centralize. Before I was mentioning that fragmentation was a problem for industry in the IP landscape. Well, with this proposal, we are addressing this fragmentation, and we are bringing legal clarity and transparency in the context of SPCs, supplementary protection certificates. If we look at the second pillar of the patent package, this is a standard essential patents. Well, just not to forget, with the new system of SPCs, we are making SPCs 55% cheaper than currently the system is. I think that's an important figure. If we look at the second is supplementary protection certificates, this is actually an area, standard essential patents. This is SEPs. This is an area where we see the need to bring transparency in the market. And again, it is actually very important to introduce this regime that we have proposed, again, for this transparency in a market where, again, for just to give you a figure of its value, we're talking about 300 billion euros involved, for example, in the area of 5G for IoT connected, where we need to ensure that there is this access to these specific standards that are called essential, that only essential standard patents are actually then registered. But just to bring that also into the picture, together with the final pillar of the patent package that relates to the compulsory licensing regulation that we have proposed as to ensure that the European Union at union level has the right level tool in case there is a crisis and emergencies to guarantee that there is enough production of a specific product protected by a patent when there is no voluntary licensing which is adequate or available at that front. So this all will, if once adopted, support the European Union, its industry, and the competitiveness of the European Union as a whole. Now, on the unitary patent, just to give you a glance, since 1st of June 2023, we have the classical route, which is the European patent opened to more than 39, I think it's members of EPO, 39, sorry, members of EPO, which, as you may be aware, once you apply for a European patent and it is granted, you still need to have the second step of going to each and every national territory where you want your patent to be protected, to be validated. That is obviously multiplying effect, and that also supposes multiple renewal fees and more costly system. So now we have this additional route since 1st of January, which is not replacing the national patent regimes, not replacing either the European patent normal route. It's just giving you the possibility, once you have applied for the European patent, to within 1 month ask for that unitary effect, so that immediately it will be actually applicable and protected currently in 17 member states. And I'm here showing the member states that have ratified the European patent, the Unified Patent Court Agreement, which is very much interlinked with the unitary patent effect, because, and let me explain you, it's a system, the unitary patent system, that has two pillars. It has the unitary patent protection that I was mentioning, that it will be applicable in these 17 member states directly. But then it also has the other pillar, which is this Unified Patent Court that has also started operating since June, and which is specific for litigation of any infringement or questions of validity of European patents, the traditional ones, and the European patents with what we call unitary effect. Now, what happens? What is the interconnection between the European patents with unitary effect and the Unified Patent Court? Well, the unitary patent protection can only apply in those territories where the member states have actually signed up and ratified the unified, the International Treaty of the Unified Patent Court Agreement. Currently, as I was saying, it's only 17 member states. We see some other member states looking into ratifying that agreement. Obviously, from the Commission side, we can only encourage member states to do so, because of the obvious benefits that it will have, not only for companies, but also in terms of investment, of attracting investment for the industries that will be using those new patent protection schemes. Now, if we look quickly at how the Unified Patent Court works, well, it's been, as any other court established with a court of first instance. There is a court of appeal in Luxembourg. There is a central division that is in Paris, in Munich. Now, there is an agreement to have that other central division in Italy as well. And there are also local divisions that member states have introduced in different territories. So we do have a unified patent court that is actually split a bit over the territory of those member states that are participating. It also has an arbitration and a mediation center set up in Ljubljana and in Lisbon, and a training center for judges. Now, since it has entered into force, I understand there is at least already 500 to 600 cases that have been already filed before the Unified Patent Court, and also in terms of unitary patents, I think it's around 10,000 registered patents. So the system is actually picking it up quite substantively in many of different services and sectors. So is a good start for this new baby, if I can call it like this, in the IP field. Now, I will not go too much into detail on the basic features of the unitary patent, because I want to also hear what Robert has to say also from the experience he has had with companies using the new unitary patent. But just to name just three, which is important messages to pass, it's that with the unitary patent we have one-stop shop procedure, so validation done by the EURPO, enforcement done also at centralized level by this unified patent court that I was mentioning, less cost obviously because you have only this one-stop shop, no need to go into the different national territories for further validation, less cost also in terms of translation, less administrative burdens, and again, important to flag, of course, that this is a uniform protection, meaning that it cannot be, limited, transferred, or revoked in one territory. So if it is revoked, it is for the whole 17 member states where currently it's being applied. Now, just also one last element, since we were talking a lot about SMEs, to raise awareness about the court fees, because these are being set up with a provision that foresees a 40% reduction for SMEs for the litigation cost in the UPC. So I think that's worth also flagging. Now, I've already spoken quite a lot about the unitary patent, and I don't know, Robert, if there is anything you would want to add from your experience in the help desk.
Yes, I will be very brief.
Thanks.
1 minute. I mean, I will just focus on what can complement what Claudia has said already, which is quite broad. Just real fast, I will mention that the new unitary patent with unitary effect, it's based on a European patent. It will be only available for now in 17 countries, so anyone applying for the unitary effect will have the protection in 17 countries by paying the fees for 4 countries, which is quite good for USMEs who want to go for the unitary effect. The next time, if they apply, for instance, in 2024, and we have 20 countries, they will have the protection in 20 countries. The way to protect it, as I mentioned, they will use the same pre-grant phase, the same high-quality search and high-quality examination as it is being carried out with the European patent by the European Patent Office. So first, they need to obtain a European patent as the ABC rules. Once there's a mention in the European Patent Bulletin that it's been granted the European patent, then they request for unitary effect in 1 month. I think you already mentioned the benefits. I will just mention one more, which is, of course, that there's only one renewal fee that has to be paid to the European Patent Office, not like before the European patent application, then you go to different countries and you have to pay the renewal fees to each IP office. Now it's all centralized at the European Patent Office, which is very flexible for companies that has not enough money to travel around or to pay the fees for different IP offices. And just to mention what I'm talking with EU SMEs, we talk about the 17 countries, as I mentioned, that are covered. So if they want to focus on other countries like Spain or Poland or Croatia, they need probably to carry out, probably select these countries. It's not, for the moment, they are not part of the UPC-A. And there's no foreign shopping, which means that if before they could go and select to which jurisdiction they would put a claim against a third party for a case of infringement and validity, Now, with the unitary patent, as Claudia mentioned very well, it's now all centralized as a unified patent court, putting into the context now more legal certainty. And I think we extra limit our time. Thank you.
Very much. And I think I will just simply conclude 3 messages. IP is very important. IP is there to help companies to protect their inventions and to allow them to scale up. And please make sure that you make in your networks, in your own domestic, constituencies, use of all the services that we have just explained, so that we can better reach and support industry and you going forward. And a big thank you to the distinguished speakers for this very lively debate. And I know we're out of time, but if there is any question, we're very happy to take it now or in the corridors. Big thank you.
Thank you.